Hi friends from around the world. In the internet age, the publication of copyright infringing contents goes very quickly, right? You know that internet functions within minutes, within hours, within a day. If you have a tweet which is impacting on the public, which is appealing, then it might go viral within, what, hours or so, and may go around the world. Or if there is a video of the crash of a plane, or a terrorist attack video, or whatever rumors are being spread about this and about that, which is in the headlines of the newspapers, so it may go very, very quickly. This possibility of publishing very quickly on the internet, well, that makes it impossible to make a preventive action. So it is about liability then if a publication is being done without the consent of the author. So it is the author who decides about the publication, among other things, reproduction, publication. So it is about the author's right, and if the author's right is infringed, so it is about liability. And this liability is being taken care of in Article 3.1, which says, well, here on the screen, we talked about this in other videos, but the liability is 3.1, which says, well, it is liable the one who makes a publication, a communication to the public of copyright infringing content, and then it is up to the authors to claim the corresponding damages, whatever it is, and make eventually injunctions. We will come to that. Now, this Article 3.1 has been transposed into the 27 legislations of the member states of the European Union, but it has been translated as such, communication to the public. So there is nothing which has been more precise being translated into the national member states legislation. Meaning that if it comes to the notion of communication to the public in the legislation of the national member states to the national courts, well, the national courts, they don't know exactly how to deal with it, what is included in the communication to the public and what is not. Then the only chance they have in order to get a clear and uniform interpretation for the whole member states of the European Union is to go to the European Court of Justice through a referral, submitting the corresponding questions, and then the question is answered, and the national court is doing its job, making a ruling according to the interpretation received from the European Court of Justice. So that is how it goes. We have now 4 cases to review with you together, which are all about 3.1 communication to the public. And here's the first case. It is about a website which links to different other websites with regard to news articles. News articles which are available, freely available on the website of, a newspaper or so, which publishes articles on a daily basis. And that one, the infringing, so to say, the infringing website, the defendant's website, was trying to collect the different sources and putting a hyperlink on it so that the lecturer of the website in question, they can access to different articles from different sources, so to say. Now, this website, the defendant's website, was sued by one of these news channels, and it went to the court, and it was about to say, well, what is it here, the communication to the public? We have here a situation where we have a freely available website on one hand with publication of articles, and and whether this hyperlink of another website to this website is something which would amount to communication to the public in the sense of Article 3.1 Copyright Directive. And the court was clear here about that we have the Article 3.1, which requires two conditions. One is the communication to the public, so an act, a positive act or indispensable act in order to something being communicated to the public, so a kind of action on one hand, and the public must be reaching out to a new public. So if the first website, the original source, is doing communication to one kind of public and the new one does not add a different public to that, then it would be, so to say, the same public and would not be an infringement falling under 3.1 of Copyright Directive. And in that case, it was not about the communication to the public as such. No, it was about the public. The source, the original source, they target the general public. So to say, everybody could freely access this content. And the the defendant's website, they did not add a new public to it. It was also the general public who could freely access through this hyperlink to that source. So being in the absence of a new public, there was no infringement from that defendant's website, putting a hyperlink to the original source. That was the first case from 2014. The second case is from 2016, and it is about so to say, a Dutch case. It came out from the Dutch courts, referring to the European Court of Justice. And it was about, again, a fancy website, not rather news-driven, but on, entertaining news. And here it was about a photo from Playboy of a model, Dutch model, which should be, or was foreseen to be published in December 2011. So it was being done, the shots of the photos of the model were being done in October. And in October, that defendant's website, infringing website, so to say, in October, they received an anonymous tip, anonymous information of that series of photos and a link to an Australian host site where it can be accessed. And that entertaining news site in the Netherlands, they published one photo and then the link to other photos which were on the Australian hosting site. So Sonoma, who was in charge of the copyright on behalf of Playboy, they requested a takedown notice against the defendant's website for the photo and for the link. And the defendant's website, they took down the photo, but they took not down the link. And then it was about, it went sour and goes to litigation through all the courts in the Netherlands, and then it goes up to the European Court of Justice, whether this is a communication in the sense of Article 3.1 of the Copyright Directive. And here, the difference being with regard to the previous one is that the previous one was uploaded to the internet with the consent of the author of the copyright, whereas here it has not been with the consent of the author of the copyright. So it was now to decide what happens with the communication to the public in the sense of Article 3.1. And here the European Court of Justice, they decided, well, it is about the two conditions we had so far, so the communication to the public, communication and to the new public, right? So these two conditions. There are two more conditions which have to be, so to say, complied with. And the new condition, so to say, was a kind of knowledge of the potential illegal nature of the content, of the copyright content. Knowledge of the potential illegal nature. And the second condition was the profit-making nature of the infringing website. So these are new conditions, so to say, which for the first time have been raised by the European Court of Justice, and this is the importance of that judgment. Now, it is important for the judgment here is that the knowledge of infringing content, so to say, the knowledge, it's a kind of tort. So that is the first time that this kind of requirement has been introduced into the copyright infringement. It is something interior. It is often not easy to prove. But the potential illegality, well, it was the first time, and it is a bit open. So we don't know exactly what is potential illegal nature. Is it you have to investigate if it is suspicious? Is it you ought to know? Is it you should have known? Or is it that you must know positively? Or we don't know exactly. But in any case, these were two conditions which has been raised by the European Court of Justice in add to the two conditions we had beforehand. And in the case at hand, we had a kind of profit-making website, even if it's an add-on, and we had the potential legal because the Sonoma already said, this is infringing content. So that was the communication to the public here was being said. It was communication to the public. And then we come to 2017, that is the third case now. And this is about a different one, also a Dutch one. There is Stichting Brain, which is a kind of foundation in order to help the copyright protection and the help not to have much infringers on, so a kind of foundation which were in the Netherlands and prosecuted, so to say, infringing situations. And there was Mr Wullems. Mr Wullems is an individual who offered in the Netherlands a kind of device, and that device, together with the internet and adds on, I don't know exactly how that technically functions, but he had adds on, which makes it possible to access directly to infringing websites and see, I don't know, movies or illegal content, so to say. And this has been sold by that individual in the Netherlands for not insignificant numbers. So that is another issue the European Court of Justice requires. The new public must be, so to say, significant in order to fall under 3.1 Copyright Directive. So that device was, so to say, sold, and they came not to a solution, both parties, and it went again to the European Court of Justice in last instance to see what it does. Article 3.1 Copyright Directive help us with that case. Now, what did it say? It did say, not the mere provision of that device is not sufficient. The contributing act, so there must be indispensable, and the contributing act is important in order to trigger the responsibility of 3.1 Copyright Directive. And here it was, so to say, the purpose of that device was to access easily infringing content and movies and so. So at the end, the European Court of Justice, you may guess, well, they did again infringing content here, because it is indispensable and it is a part of contributing to the access of this infringing content. So it is part of the communication to the public. Let's come to the fourth case now. Yes, 4 cases. The 4 cases about the Pirate Bay. I don't know whether you have heard of the Pirate Bay. They claim themselves to be the most resilient, infringing website on the web. Well, it is about it is about peer-to-peer. So the business model, so to say, of Pirate Bay is not that they put infringing content on the web in order to being seen by the users. No, it is that the users, they put the infringing content on the internet, and it is up to the Pirate Bay, who is indexing this content, this copyright infringing content, and making it, so to say, well, it maintains that website so that new public can access that content. That is the Pirate Bay. And we have again Stichting Brain, so the one from before, as the foundation and the prosecution of copyright infringement. Here again, it went up to the Court of Justice. And the Court of Justice, well, they had here a small problem. It was about an injunction. Injunction is about Article 8 of the Copyright Directive. So in the case of infringement, communication to the public, the author, so to say, or whatever infringement it is here, has the possibility in order to make an injunction. But the injunction refers to an infringement in Article 3.1. So again, we are here with 3.1 of the Copyright Directive. And here, the Court of Justice, well, they did some reflection about what is the intermediary, because we have here a kind of intermediary. And the intermediary, this is the Pirate Bay. It is, so to say, the one in the middle between the end user and the copyright owner. Well, what did it do? If it is only the management, that would not be really a contribution, but they do the indexing of the different movies, so to say, of different infringing content, and which afterwards is being used for the search of the users, which then facilitates the whole process. So in that case, it is beyond the maintaining of the website, so it is an active contribution, so that the infringing content could be accessed by the users, by the end users. So it is being considered as an active contribution with regard to the facilitating the content. And again, the European Court of Justice come here to the conclusion that would constitute a communication to the public. Now, the whole thing, communication to the public, and this part here, the intermediary, is also important for the trademark infringement and the safe harbor clause. So it goes into the same sense to see whether a intermediary is just putting at the disposal its website, or is doing actively something in order to put the content on the website. So it goes a bit in the same direction here, but still we need to know further what happens with the potential illegal content and the knowledge thereof of the communicator to the public and its liability. We will see how this play out. But you get now a rough idea on what is Article 3.1 and what is the tendency of the court and how it evolved over time and how is it today, so to say. How is it in your home jurisdiction, I wanted to know?